All right, so tonight we're going to talk about, and go ahead and type your questions and your comments as we're going along. When do you have to consider this? Consider you're out and about in society, and there are authority figures out there abounding, and some of these authority figures, government, law enforcement, or otherwise, security guards, whatever the case may be. What legal duty is created between you and those people when they accost you and even accuse you of committing a crime? So you're the focus of a criminal investigation, or you're a suspect in a criminal investigation. What duty do you have to cooperate? Do you have to cooperate? What duty do you have to identify yourself? Do you have to identify yourself? What duty do you have whatsoever? So I'm going to give you a sample case on this. Okay, so this is an excerpt of a motion filed by one of my students in a criminal case where this gentleman was accused of disorderly conduct and refusing to cooperate with the police, refusing to give his name, refusing to produce identification. Actually, he gave his name, but he refused to give identification even though he was a prime suspect, and even though he became arrested eventually in this case, he refused to give identification. He told him his name, but he didn't produce some government ID to the police. And they charged him with obstructing a police officer, which is obstructing justice, and charged him with disorderly conduct as well. Put my eyes on here. Okay, now this is the motion that he made to Judge Lisa Trackman in the Broward County Court. If anybody from Florida knows her, she's a very, very, very good judge. Lots of bad judges out there. This one is not one of them. We've had 3 or 4 cases in front of her and legitimately won all cases in front of her. Not because she just likes pro se's, it's because she's just a fair judge. She doesn't put up with any governmental crap, and she knows when the cops are lying. Okay, so this gentleman, I'm going to use his name because he's deceased, and I've used his name in the past, and I even used his name in my book, Robert Genesis, and a good friend of mine for many, many years, still a good friend of mine even in death. So this is a 3.190C4 motion, which is a motion to dismiss the case for which he had been going on for some 14 months. Regarding his alleged criminal conduct, which was refusing to cooperate with the police by giving his name while he was a suspect, and then when he was arrested, not refusing to give his name, refusing to produce identification, and then refusing again to produce identification after he was arrested. So this is basically what happened. So just listen to it's a brief motion. So listen to the circumstances. The undisputed facts, and the reason why they're undisputed facts is because he deposed the police officer before he made this motion. Deposing a police officer is sending a subpoena to him, which you have all the right to do. You don't need anybody to send a subpoena. You have the right to subpoena power. Nobody has any more power than you do. Government only mimics your power. They don't exceed your power. So he subpoenaed the police officer, brought him to a court reporter's office, and questioned him about his version of what happened. We're not going to argue whether or not he's a liar or whether or not his version is true. The fact is, what he says, if Robert Genesis agrees with it, it's undisputed. If he says ABC and Robert Genesis says, I agree, ABC is undisputed. So the undisputed facts of this case were that Robert was allegedly creating a disturbance by arguing with a store clerk and refusing to leave the premises in Broward County here. The arresting officer, and it's public record, so we can say, Jose Izquierdo, admitted in his deposition and through his incident report that Robert was observed as being calm when he first arrived at the store at the scene. So the clerk called the cops because Robert wouldn't leave. The cops got there, and their first observation was Robert standing there across from the clerk, and neither of them discussing or talking whatsoever. So his first observation was that. And then he said after he arrived that Robert escalated to anger once he got outside the store. So here is a exact transcript from the questions that Robert asked the police officer during his deposition. Okay, Robert says to the officer, "What would you say my demeanor was throughout the incident from the time you arrived to the time that you left?" The officer said, "Angry, calm." Okay? Robert says, "Which one? At what point was I calm and at what point was I angry?" Officer Izquierdo said, "I believe you were calm at the time I entered the store. At that point on, it escalated into anger." Robert says, "So from the point you entered the store, nothing was really going on. You entered, and what did you observe?" The officer says, "I observed you and the clerk standing closely to each other. He was behind the counter. I walked in. I spoke to the clerk to see what was going on, and I believe I asked you a question which I don't recall at this point in time, but I spoke to both of you." Robert says, "And my demeanor at that time was, you say, calm?" The officer, "It was calm at one point, but it began escalating to a higher degree as you stepped out of the video store." Now, the arresting officer also stated that he observed no criminal activity on the part of Robert at any time during the investigation, notwithstanding what he interpreted as Robert's refusal to give him identification and his behavior escalating to anger. That's a side note. Back to the deposition. Robert says to the police officer, "Did you observe any kind of disturbance when you first arrived?" "Not when I initially entered the store," the cop says. Did you feel threatened at all when you were at the scene?" "Nope," the cop says. "Did you observe any disturbance at any time during the time you were there?" "Yes," the cop says. "What point was that?" Robert says. "When you began to argue with the clerk." "And what was my argument?" "I believe it was to the effect that you wanted to speak to somebody other than the clerk himself." Side note, the arresting officer stated that Robert's calm escalated into anger once he stepped outside the store. However, the arresting officer's testimony did not support his contention that Robert was angry at all. In any event, Robert was not charged with disorderly conduct or trespassing, so I correct that, by the way. He was charged with refusing to produce identification, which equates to obstructing a police officer. A crime not to identify yourself with identification to a police officer. Welcome to Nazi Germany. Okay? Which isn't the law. And this guy found out very shortly that it's not the law. In any event, Robert was not charged with trespassing or disorderly conduct, and the sole criminal conduct alleged by the arresting officer was that he refused to give him identification while he was conducting an investigation, and not for answering his questions about the investigation. "I'm a police officer. I'm investigating a homicide. I'm investigating a murder. I'm investigating a stolen apple. I question you, sir, and you have a duty to answer me and tell me everything you know, and if you don't, you get to go to jail for not telling me the truth, the whole truth, and nothing but the soup, so help you God." That's what one would think, but that's just not the truth. That's not the case. So we continue on with the deposition. Robert says, "Would you consider that when asking a question of a person, that if that person doesn't want to answer the question, it's an obstruction of justice?" The officer says, Well, I believe if I ask a person to identify themselves due to the fact I was conducting an investigation to give me any kind of facts of what was going on from their behalf, then it's obstruction. So if you don't defend yourself and tell me why that I shouldn't arrest you, I'm going to arrest you for that crime, the cop's saying. Okay. If they choose not to speak at all, Robert says, would that be considered an obstruction of justice? It could be construed as obstruction, says the police officer. From God's mouth, from his mouth to God's ears. It could be construed as an obstruction, Robert says. Is that the only law that you know of that covers obstruction in your mind? Obstruction of justice, is that the only law that you're familiar with that pertains to that situation? Also, resisting arrest, he says, the cop says. Okay? Resisting. And that would be resisting an officer, Robert says. Cop nods his head, yes. Robert says, would I be correct in concluding that you arrested me solely for not giving you identification? Correct, the officer says. And refusing to answer my questions and attempting to leave from me as I was attempting to question you in regard to the events that occurred. If I'm questioning you, you can't walk away and leave. Want to bet? You can walk away anytime you want to, unless he says, halt, stop, you're detained, sir. You're not to leave, you can't go. Or if there's some reason why you believe, as a reasonable and prudent person, that you can't leave, well then, you can't leave. But Robert said, I don't really think I want to discuss this whole thing with you, so I'm going to go home. Goodbye, good night. No, you're not. I'm conducting an investigation. Give me your ID, sir. Produce your papers to Nazi Germany. Okay, it's abundantly clear that he went on to say in his motion, talking to the judge now, that the grounds used to support the arresting officer's charge of obstruction against me was solely based on the fact that I refused to give him identification, period. And that I wanted to walk away, and that I wouldn't talk to the guy. I didn't want to talk to him. I wanted to remain silent in the face of a criminal accusation. Something in the Fifth Amendment or something like some abstract Bill of Rights talks about your right to remain silent. Okay, so he wrote a memorandum of law supporting the fact that case law after case law after case law says in the face of criminal confrontation, accusation, you have the complete right to remain silent. That's what the Fifth Amendment's for. You don't got to talk to him. You can leave whenever you want to leave, unless he says don't leave, or unless the situation is such that a reasonable and prudent person would know I can't leave. A guy's got a gun drawn on me. I bet you I'm thinking to myself, I better not move. I better not make any fast moves. And I certainly don't think I'm free to turn around and walk away. So a little bit of critical thinking, case-by-case basis, no bright line. Just if you think, as a reasonable and prudent person, that you can't leave, you can't leave. You're detained, and that is technically an arrest, which is remedied under Title 42, Section 1983 of the United States Code, which is the Civil Rights Act, for false arrest and false imprisonment. Even a short little encounter. Now there is a level of probable cause that the police enjoy. We don't want our police officers to be worried that every time they make an arrest that they're going to be sued for false arrest or false imprisonment. But we do want them worried about that if they're abusing their power. We want to teach them how to treat us. You teach them to bully you, they're going to come back and keep slapping you around. Okay, now here is what the United States Supreme Court says about this particular issue on point, okay? And this is from, let's see, Brown versus Texas. The case site is 443 U.S. 47, 1979, Supreme Court of the United States, okay? And don't forget, like we talked about last week, you want to find that, go to your law library, go to the librarian, ask her where the United States reports are. That's what U.S. stands for in this citation. And there's numbers on either side of that U.S. The first one is 443. So you go where she tells you to go, and lo and behold, you'll find 999 volumes of the United States Court Reporters. And you go find volume number 443, and you pull that book off the shelf. And you turn to page 47, and lo and behold, will be the beginning of a case called Browns versus Texas, which is an opinion written by the United States Supreme Court. So here's the colloquy between, and of course, the United States Supreme Court, they govern the law, they govern the case law in the land. Every state has its own case law, and it is binding upon those states. Federal law and United States Supreme Court is binding upon all the states, okay? So this isn't just to Florida, this is for everybody. So they were having a discussion about a couple of black gentlemen who were in an area that was high crime, and the police officer had not seen these black gentlemen in that area previously. So they wanted to go stick their nose into their business. And can they do that? Can police officers go and stick their nose and sniff around and detect things and be detectives? And of course they can. They can question people. They can say, "Excuse me, sir, have you committed any crimes lately, and would you like to admit or confess to them to me right now so I can arrest you and take your liberty from me and your property as well?" And you can say, "Not today, thank you." Or maybe you want to confess and you want to go to jail. It's up to you. Go for it. So this was between the panel of the United States Supreme Court and between the Arizona prosecutor, Mr. Patton. And this was because they arrested this black gentleman because he refused to give identification or even identify himself to the police. Okay? The court says to Mr. Patton, the state of Arizona prosecutor, or Texas, I'm sorry, state of Texas. "What do you think about if you stop a person lawfully," the Supreme Court justice says, "and then he doesn't want to talk to you? Do you put him in jail for committing a crime?" The prosecutor says, "Well, first of all, sir, I would question the defendant's statement in his motion that his First Amendment rights give him, an individual, the right to silence." Interesting, very interesting. The court says, "Well, I'm asking you, why should the state put you in jail because you don't want to say anything?" And the prosecutor says, "Well, I think there's certain interests that have to be viewed." And the court says, "Okay, that's what I was waiting for. I'd like you to tell me what those are." I embellished a little bit. Mr. Patton says, "Well, this is a comprehensive intellectual statement here, so listen carefully because you might get lost. Well, the government interest to maintain safety and security of the society and the citizens to live in the society, and there are certainly strong governmental interests in that direction, and because of that, these interests outweigh the interest of an individual for a certain amount of intrusion upon his personal liberty. I think that these governmental interests outweigh the individual's interest in this respect, as far as simply asking an individual for his name and address under the proper circumstances." And the courtroom applauds, of course. The Supreme Court justice says, "But why should it be a crime not to answer?" And Mr. Patton says, "Again, I can only contend that if an answer is not given, it tends to disrupt." What does it disrupt? That would be the question I'd ask. That's what the Supreme Court justice asked. Mr. Patton said, "I think it tends to disrupt the goal of this society to maintain security over its citizens, to make sure that they are secure in their gains and in their homes." God bless you, Mr. Patton. Thank you. I know you love us all and you want to take care of us all. That was a great answer, but sorry, it wasn't good enough. The Supreme Court justice says, "How does that secure anybody by forcing them under penalty of being prosecuted to give their name and address even though they are lawfully stopped?" "Well, under the circumstances, Mr. Patton says, in which some individuals would be lawfully stopped, it's presumed that perhaps this individual is up to something, and the officer is doing his duty simply to find out the individual's name and address and to determine what exactly is going on here. We need to know what's going on. We need to know what's going on with you guys out there. The Supreme Court says, I'm not questioning. I'm not asking whether the officer shouldn't ask questions. I'm sure they should ask everything they could possibly find out. What I'm asking is, what's the state's interest in putting a man in jail because he doesn't want to answer something? I realize, the Supreme Court Justice says, a lot of times an officer will give a defendant a Miranda warning, which means a defendant doesn't have to make a statement. Lots of defendants go ahead and confess, which is fine if they want to do that. But if they don't confess, can you put them in jail? You can't put them in jail, can you, for refusing to confess to a crime. End of story. You lose, we win. So that's the Supreme Court Justice on that particular case. So now you know the answer is, you don't never got to talk to them under any circumstances. If you're standing over the 17-pound cocaine stash with 8 dead bodies around you and a smoking machine gun in your hand with their blood all over your body, you don't have to say a freaking word, okay? Say nothing. You better off say nothing. I'm not encouraging criminal activity, but I am encouraging resistance to what they call criminal activity, which is pretty much, 94% of all the people who are in jail in this country are all there for non-violent crimes. Only 4 or 6% are there for violent crimes. The rest of you are there because of what you want to ingest in your bodies, because you are not polite, because you refuse to produce your identification to a police officer upon demand, or you don't tip your hat, or you don't when you walk by. Remember this, because the black people remember this real well. Whenever you see a cop, make sure you bow your head and you never make eye contact with them. And you do the yes master to them the whole time. And not, okay? Those days are gone for everybody. They are our servants. We are their masters. They have a job to do. They do a lot of good, and they do a lot of bad. To me, they have lost my respect as a former police officer myself. They've lost my respect. They don't deserve the rating of I respect you on sight anymore. They deserve the I'm suspicious of you, what are you trying to arrest me for mentality. So when I'm in a bad area and I see a gang of people coming at me, I got my hand on my pockets and my hand covering my wallet, and I'm making a beeline for the nearest house or car to lock all my doors. That gang I'm talking about is the police. Okay, now this was what Judge Lisa Trackman of the Broward County Court said to Robert Genesis after he made this motion, after he made oral argument. She was the judge and the jury because it was a misdemeanor and there was no jail time involved because the state certified no jail time. We're just going to convict you of a misdemeanor. We're going to fine you money. We're going to give you community service. We're going to put you on probation. We're going to put you in the system. And then, of course, if you break probation, then you get to go to jail for the entire 1 year, which it was. So he decided he wasn't going to agree to plead guilty to a crime that didn't even exist, which was a ridiculous interpretation by the police officer about that. So Judge Trackman says, this is his oral argument first. This is Bob's oral argument real quick. Your Honor, this case is very simple. It comes down to the following. I'm charged with resisting officer. It squares an arrest. My first point is that I was not arrested for any crime to which I have been resisted. So how can you be arrested for resisting arrest if you haven't committed a crime yet? So obstructing a police officer is a resisting arrest. So what did I resist arrest to? I wasn't in arrest yet. I resisted arrest to my resisting arrest charge, which don't make a lot of sense. So that being said, Robert says, maybe the state is then considering that obstructing the officer's criminal investigation was the problem. In either circumstance, the undisputed facts do not rise to a level of resisting arrest or obstructing an officer. My second point is, Officer Escobedo swore under oath at his deposition that the only reason he arrested me was, number one, I refused to give him identification. That's not true. That is true. I agree. So Robert is agreeing to this. If he says I dispute it, then we got to go to trial, and we got to have a judge decide who's lying and who's not. But if you say ABC and I agree to ABC, well, it's just over. It's just time for the judge to pronounce sentence. That's it. So he said, I refuse to give him identification. He's right, Judge. I refuse to give him identification. Number two, he said that I refused to answer his questions about the incident at the store. Again, ding, ding. I refused to answer his questions. In fact, I didn't even like him. He didn't say that, but I know he didn't like him. Okay, number two, I refused to answer questions. I agree. That's an undisputed fact. Number three, he said I attempted to leave him as he was questioning me in regards to the event that occurred in the store. Ding, ding again. I did. I attempted to leave. I agree. That's an undisputed fact. It's important to note that all the time I was not under arrest. I didn't try to leave when I was under arrest. I always tried to leave when I wasn't under arrest. He told me, no, don't leave. And I said, okay, I won't leave now. In his deposition, he said, and I'm quoting, I said, would I be correct in concluding that you arrested me solely for not giving you identification? The officer, correct. And refusing to answer my questions and attempting to leave me as I was attempting to question you in regards to the events that occurred. I was not arrested for not giving, I was arrested for not giving identification, Robert says, and not answering questions and attempting to leave while he was questioning me. And since it's not a crime to refuse to give identification to the officer under the circumstances, and it's not a crime to refuse to answer his question, and it's not a crime to attempt to leave when I'm not under arrest, none of those are a crime. And since I've agreed to all of his facts, the only thing left for Your Honor to do is determine the law. Did I break the law? Am I a criminal? You're going to put me in jail. As the cases I've cited in my motion support, Florida courts have held that the right, quote, that the right to remain silent means just that and has no exceptions. Also, other courts have held that silence in the face of police questioning is constitutionally protected. Finally, the Supreme Court in Brown versus Texas back in 1979 said, you can't put a man in jail for remaining silent. The only thing left to decide, Your Honor, is where to bury the body. And that was the end of his oral argument. The state attorney's response said, after consulting with my colleagues and the pertinent case law on this matter, Your Honor, we have determined that regarding the arrest of Mr. Genesis, he was not required to answer any of the officer's questions. He was not required to produce identification or even identify himself, and he was free to leave at any time during the officer's questioning. Therefore, we enter a nolle pros, case dismissed, case over, done. That's pretty simple. Now the judge says, she smiles at Robert, and she calls him up. He says, Mr. Genesis, you've conducted yourself extremely professional during these hearings for the last 14, 16 months. You've been impeccably attired and timely at every appearance, and the eloquence of your arguments are better than most of all attorneys I have come before me. Sir, this case is dismissed, and I wish you all the best of luck in your life. You're free to go, sir. The judge had a big smile on her face during her statements, and she was obviously proud of Mr. Genesis and what he did. Mr. Genesis filed a suit against the officer under Title 42, but unfortunately he passed away before he could complete it.